Okay, I think that before I allow Mr. De Beer to respond, Mr. De Beer, you're also appearing on behalf of the Commission in relation in the Dr. Malapane's matter. Is that so?
Justice Ondi, Mr. Tsele is appearing for the Commission in that matter, and he's still on the. As far as I know, he's still here. I'm sure he still is here. Yes.
So, all right. Do you want to respond now to Shabalala, or do you want us to wait until you finalize Malapane? Because Malapane, it's also an in-person.
Justice Ondi, if entirely in the court's hands, if the court wants to hear Mr. Malapane, Doctor, sorry, apologies.
Doctor,
first,
yes.
Apologies, and then for me and Mr. Tsele to answer. I'm satisfied with that. I've got no difficulties.
Mr. Malapane. Mr. Malapane.
Thank you, Justice.
Yes.
Yeah, my camera is going to take some time, but it will catch up.
No, we can hear you.
All right, thank you, Justice. Well, let me start by thanking the Honourable Court and also thank the Honourable Council for allowing me to go here. I appear as an independent candidate, and then I appear in person in the case number 0010/24 EC. And then I've been a participant in these elections, or a hopeful participant in these elections, depending obviously on how the outcome of these proceedings will go for the Gauteng region, for the 2024 national and provincial elections. Basically, I'm intending to contest for the Gauteng region for the seat in the National Assembly. Your Honourable Justice, I have structured my presentation in two parts, Part A and Part B. I'll just go straight to that. Part A is that which seeks to deal with the motion or Notice 2915 of 1998 of the Electoral Court Section 7, which reads that failure to comply with the limits or directives states, or failure to comply with the prescribed time limits of the directives of any court having jurisdiction will, by mere fact, also result in a party being barred unless such a court on good cause shown directs otherwise. I would like to submit to the court that in terms of the respondent acted outside the time limits of the directives of the court. And then they have not shown, as far as I'm concerned, any good cause which the court needs to consider in terms of accepting or not barring them in terms of the prescriptions of this notice.
Yes.
Yes. And then I would also like to mention to the court that despite the respondent acknowledging receipt and forwarding of my emails to their legal team, which is also on paragraph 19 of my reply affidavit. Besides them indicating that they've received them and forwarded them, so they did not bother, to follow the due and proper process in terms of applying to the Honourable Court for condonation, or maybe even to grant any reasonable, to grant any reasons as to why they are delayed. Now, in terms of the directives which were given by the court on
Dr.
the
Malapane,
18th.
Dr. Malapane,
Yes.
take it that we have read your papers. We also have read your heads of argument. So the first complaint is that the respondent should not have been allowed to file an answering affidavit in circumstances where it was late and there was no application for condonation. And then in terms of Rule 10 of the rules of this court, they should have been barred. That's your case.
Yes.
Is that so? Okay.
That's correct.
And then as far as the merits are concerned, you say your complaint is not that the IEC online portal was faulty. Your case is that the cutoff time was too short, considering the amount of data that you needed to upload from the 6th of March 2024, when you got registered, until the 8th of March 2024. That's your case, as I understand it. Am I correct in my understanding?
Yes.
Yes.
Right.
But now, and then
Yes.
the INC response is that, well, you did not qualify because you submitted only 927 signatures. In other words, the support information, the support people that you submitted, instead of submitting 1,000, you submitted only 927, so you were short, and therefore there was a reason. The delay was on your part.
Yeah. Yes. That is how the commission will put it, Justice. But if you can look at on what it's in my argument, especially on Part B, because of Part B of my submission deals precisely with the primary matter, yes, exactly as the Honourable Justice has indicated. Now, in line and in context of the letter that I had wrote to the IEC, I argue that, you know, it is not out of practice or something alien to the IEC, you know, to allow that queues be allowed to be completed, even though there's closure. If you can look at what I've said in terms of there's this presentation that I've brought forward, which says systematic closure. In that, what I'm saying is that if you look at the conduct and the function and operation of the commission, even in terms of elections, should the deadline arrive whereby they need to cut off the queue, they do not necessarily cut the queue and chase everyone out. What actually they do is that they lock everybody who's in the queue inside the premise so that they can conclude the process. So my argument with the commission in this case is that because by the time when the deadline of the 8th at 5 o'clock hit, I assume that in practice and in fairness, we were part and parcel of people who were in the queue. So because of the process had already been began. So instead of them cutting off the queue, even people who are busy with the applications, they should have allowed a systematic closure so that those who are already engaged in the process be allowed sufficient time to conclude their submissions on their applications. Because of these are people who arrived on time. We arrived on time to begin the process. I need to highlight to the Honourable Court this one, Justice, that in order for us to get these 927 signatures of supporters, we did not enter 927 signatures. These are 927 valid signatures. Basically, it means that we entered more than 927 signatures. From the top of my head, I can estimate that we entered at least about 3,000 signatures for us to can qualify for 927 signatures which are valid. These are 927 signatures which are valid. Now, if the IEC gives us the same treatment and the same common respect that it grants to voters on an ordinary day, because of if they say, for example, gates are going to be closed at 7 o'clock, and then by 7 o'clock, there's 500 people who are still on the queue. They're not going to turn all of those 500 people away on the queue. They're going to let them inside and close the gates by closing them inside the premise so that they can conclude the process of voting which they had already begun. So this practice, I believe that the IEC should continue with it across all their processes, not to select that when it's time for us as candidates, we should be limited in this fashion, and when we are going to as voters for the very same process, but now under different cap as voters, then we should be treated differently. And then I began by pleading to the conscience of the IEC to say, let us consider something like this, but they did not, give an eye and ear to that. So that is why I ended up having to come to the Honourable Court to say, this is not in line with the practical principles of Batupel. In any other institution, whether be it commercial or whether be it in banks. Even in banks, if they say a bank is going to close at 5 o'clock, and then there are people, they are not going to cut those people, but what they're going to do, they are going to let all their clients inside, and then they're going to close the door so that whosoever was there before the cut-off time of 5 o'clock be serviced so that they can go. So this is the same principle that is generally applied, which I expect that the IEC should have considered in terms of this. Now, the IEC, Honourable Justice, is saying for this election, they've brought up this new system, the OCNS system. It's a very new system. It's a very new system that has not been tested before. But in their papers, they are saying they have perfected the timetable of the elections over a period of years. Fair enough, they've perfected a timetable over a period of years. But this is a unique environment now. Over a period of years, they were not using this system. This is a brand new system. So they cannot limit it and hold it rigid to what they've been used to, or simply conform to what has been always been known to them over the years. Over the years, we did not have independent candidates. Over the years, they did not use this system. Obviously, they should have accommodated that there can be certain challenges unknown to them because this was not tried and tested before. This is the first time. So they should accommodate within this if they are a responsible and accountable authority. And then the IEC does not have a competition in this country in such a way that if they do not perform perfectly, then we can have an alternative authority that can run elections. Therefore, it means they should accommodate themselves sufficient time in their processes and timetables to also accommodate that should there be challenges, what is it that we're going to do? Because this is a new system that is going to be applied for this type of elections in this country. And then in one of their arguments, Chief Justice, they are saying this whole setup was my own doing. I brought this upon myself. They are saying on the 24th, I think 24th or 29th of January, they began to invite known participants to come, for briefings and all that. And then they are saying there was no way that they could have known of my willingness to participate in the elections. Therefore, I was not invited. Therefore, the Honourable Justice, it means the very same commission themselves, they were not going in terms or in respect of their own timetable, because their timetable was allowing the obvious reason that there could be people on the next day who can begin to show hands that they are now willing and available to be part and parcel of the elections. And they did not accommodate as to what will happen to that. Now, they are saying they have raised an issue of cases. They are saying there's a number of cases, success cases that they are raising, that this number of cases are a success. These particular participants or potential political candidates were able to comply. But then these people who were able to comply, they have so benefited from this process, which automatically, indirectly decided, to prematurely cut some of us off, because they gave people sufficient information and briefings before the nomination process can be concluded. They did not put in place a system whereby as and when we come in and as and when we get identified, we can be given the same opportunity and quality that they've afforded to these other ones. So I will not compare myself with people who were called to provincial briefings and meetings, given all of this attention when they had. Some of us are not as skilled in terms of IT. Now, there are some of these people, even if they would have appeared to be in a similar position like mine, they benefited from these arrangements, which were prematurely orchestrated or prematurely run by the commission. So the commission should have put in place a system whereby all of us, when we come in place, as and when we come, we should be when we identified, we should be recognized as such.
Yes, you have made a point, Mr.
Yes.
Dr. Malapane. What remedy are you seeking? What relief are you seeking? What do you want us, this court, to order?
Okay. In line with my the remedy is in line with my funding. It's contained in the funding affidavit. It will just be given a minute. I don't want to end up quoting something fresh. But I am going to be brief in it, in respect.
Okay, let's go to a notice of motion and see.
Yes.
Do you want to be given 1 or 2 more days for the respondent to open the nomination for those candidates who are already on the system so that they can complete that process? Is that what you want?
Yes, yes, Chief Justice.
Okay.
So
you need 1 or 2.
Yes, because
1 or 2 more days.
Yes, 1 or 2.
Okay.
Yeah, 1 or 2 more days, so that we could be able to finish the process.
Okay. Is there anything further that you want to say?
No, Chief Justice, that will be all. Oh,
Okay.
Justice.
Thank you.
Honourable Justice, I keep on saying.
Thank you. Okay, thanks, Dr. Malapane. Let me, Justice Song, any question for Dr. Malapane?
No, thank you. I have none.
Yes, Justice Lance.
Nothing from my side, Justice Zondi, thank you.
And then Professor Ntlama Makanya.
Same here, Justice as well.
And then Professor Pogo.
Nothing from my side, Judge.
Okay. Is it now Mr. Cowan or Mr. De Beer, or who's going to start now?
Thank you, Judge. So it'll be me first in the Shabalala matter.
Yes.
And then Mr. Tsele for the Dr. Malapane matter. And I must apologize again for misindicating his qualifications. Justice Sondi, I really don't have all that much to say. What happens in this case is that the party, the AAAC, applies for registration in late 2023, and its application for registration is not complete. Certain information is missing. So the Commission, as it does, and as this court knows from recent cases, asks parties that want to register, please amend or rectify or provide us the missing information. And the AAAC and applicants do so, and they only do so late in February. The Commission then registers the AAAC as a party on 26 February, which of course is right before the deadline on the electoral timetable for candidate list nominations and the signature quota requirement for unrepresented parties. My Lord, all the applicants' entire case is this. Oh, and the applicants, they don't submit anything. They don't submit this. This isn't a case where they tried to submit and there was an issue with the system. There's no evidence of them attempting, nothing. All the applicants do is they say the letter of registration was dated the 4th of Feb. And they come up with a, Justice Ondi, I see your lights have come off.
Yeah, I don't know. There's a problem in this court.
I was there last week. Judge, I was there last week, Thursday. Anyway, I ran up and down as one does. So they latch onto a letter dated 4 Feb, and they say the Commission, for some reason, didn't disclose to them that the party had been registered early on, and that if they had been told, then they would have been able to comply with all the requirements. And there really are two answers. One, it's a typo. And the applicants knew about this because they submitted more information after the 4th of Feb. And two, there's no evidence to show that if they had been registered on the 4th of Feb, they would have met the deadline. As I said, this is not a case where they had the documents in boxes that we've heard of before. So Judge Zondi, my submission is quite simple, that really the case, there's no case here at all. There's no attempt at compliance. The applicants just waited too late in the day. In the other cases, there's reference to parties still being able to do things. I'm not even going to raise that now because it's not on these papers. But the simple point is, if you want to contest the election, you've got to fulfill the requirements. and you've got to make sure you do it on time. And it's not the Commission's job to bend over all the time for every single party. The Commission needs to be even-handed, and the Commission hasn't really done anything wrong here. And the Commission really just says the application should be dismissed.
Thank you.
Thank you, Justice Zondi.
Mr. Tsele.
Court.
Sorry, before any Justice Song, any question for Mr. De Beer?
Thank you. No questions.
Justice Adams, any question for Mr. De Beer?
Nothing from my side, Justice Zondi, thank you.
Professor Ntlama Makanya, any question?
No question as well, Judge. Thank you.
Professor Pogo, any question?
No question from my side, Judge. Thank you.
Okay. Yes, Mr. Tsele. Thank you, Mr. De Beer.
Thank you, Judge.
Thank you.
Mr. Tsele. Yes.
Thank you, Justice. Thank you, Justice Zondi. Justice Zondi, I am here, but I've got some rain where I'm at, and my Wi-Fi connection becomes a problem. Is it possible to just keep my camera off?
Yes,
for
yes.
purposes? Thank you very much.
It might help, yeah.
Yes.
I'm going to switch mine off as well because I'm not sure what's going on here. There's it's dark here now in this court, so I'm not sure what's going on. Okay.
I hope you can take your notes, Justice Zondi.
Yeah, okay, but at least I can still see my bench book. Yeah.
No, wonderful. Yes.
Sure.
Justice Zondi, I will equally be brief. I want to say something, a few things. The first thing is, of course, we've already dealt, particularly in our consolidated heads, and I think it's practical, and we expect that this court will deal with all the issues in one fell swoop holistically in this matter. So I'm not going to repeat some of what, for example, Mr. Bishop had said. A lot of what we say in our answering papers applies across the board. But can I just say in relation to Dr. Malapane, the undisputed facts are these. He registered himself for the first time as an online party administrator on the 6th of March. And this is somebody who now says that he's not an IT expert. He doesn't understand how the system works. And then he first captured his first supporter at 21:38 on 6 March. Later that day, it doesn't explain why he waited some 9 hours after registering himself as a candidate. But the more important point, having regard to what he said today, and it's quite clear that he attempted to comply like the other parties at the 11th hour. But the more important point made in his affidavit, in his founding affidavit, and what he says today is this. He says he didn't know how the process worked. And he wanted and he was eager to do so. But he only went to the IEC's offices on the 6th of March. He says, since the beginning of the year, and I assume, and he says, since the beginning of the year, I've been enthusiastic about this. I wanted to follow this process and to register myself to participate in the election. There is absolutely no explanation in the papers as to why he waited until the 6th of March before going to the IEC's offices to seek clarity. And he doesn't say, even after I had sought clarity, which enabled me to register on the 6th of March as an OPA administrator, doesn't say, well, I faced difficulties. And the difficulties I faced, I tried again to get hold of the IEC. As the other parties allege, nothing of the kind. So he's received the clarity he gets. If he's not satisfied with that clarity, he never goes back to the IEC on the day or on the following day. But more importantly, he never alleges in his papers that the system malfunctioned, as the other parties allege, for example. So you don't need to consider that issue, not an issue of a malfunctioning system. The closest it comes to is, well, it wasn't an easy system to use. Well, if it wasn't an easy system to use, you should have sought clarity, and you should have sought clarity timelessly. He's done none of that. The point he makes this afternoon, which is, well, I want to make an analogy about people who are queuing in an election to vote they're entitled to vote even if the cutoff time for the election comes and they're in the election venue. I deal with that. We deal with that in paragraph 59 of the answering affidavit, which is, the point is simple. The analogy is inapposite, because this is not a question of somebody who's in a queue waiting. He's arrived at the election venue, got his ID and everything he needs to vote, but can't vote by 5 o'clock because there are 5 or 6 or 7, 8 people in front of him. When he's in the venue, he's quite right. The commission would close the door and allow those to finish. But there was no queue here, and that's the point. He was not waiting in a queue, waiting for other people to upload onto a system, and then he would get his turn. So the analogy is inapposite. He had all the time in the world. He was not restrained by a queue to do what he had to do. So for that reason, that analogy doesn't work, doesn't help him with respect. The rest of the issues, quite frankly, as I say, are dealt with in the affidavit, in our affidavit. He doesn't say the system malfunctioned. The high watermark is that high watermark of his case is that he wasn't too au fait with IT. But as I say, no explanation as to why he let it lie until the 6th. And even after the 6th, if he had experienced any difficulties, there's no attempt to engage with the IEC. There is an attempt ex post facto days later to use his words again today, appeal to the conscience of the commission, and with great respect for all the reasons set out in cases like Liberal Party, etc. A plea ad misericordiam is not helpful. You can't just appeal generally to the moral conscience of the commission because you failed to comply or meet a particular deadline. So for all those reasons, Justices, the application falls to be dismissed. Justice Zondi, those are my submissions in relation to this matter. My attorneys implore me to make one comment in relation to a submission that was made earlier, not by Dr. Malapane, but I think it was I can't remember who it was. But I just want to make that comment, Justice Zondi, because it was a serious attack or slight at the Commission. There's an annexure, I think it's the African Alliance Party, an annexure that was referred to, and it was said that that annexure, EC12, in the replying affidavit of that party, it was said that that annexure discloses that the system of the Commission would automatically kick you out every 20 minutes. That's not correct, but I don't want to tell you factually why that is not correct. All I need to say is this: as a matter of law, Council cannot in reply pick up an annexure and say, look at this annexure, this is what it says, and interpret an annexure for a proposition not pleaded in the body of the affidavit. So you won't see in the body, as vis-a-vis annexure EC12, an allegation that automatically, notwithstanding the circumstance of what you are doing, you will be automatically kicked out every 20 minutes. There is no such statement made in relation to EC12, and Swissboro, DF Wendell Trust, and all those cases are very clear. If you're going to rely on an annexure for a particular proposition, plead it in the body of the affidavit so that the other side can deal with it. You certainly can't interpret the annexure from in argument as counsel, and you certainly can't do so in reply, particularly when you're now seeking to impute, as it were, on the part of the Commission, some shenanigans. But that statement is not correct factually. I won't tell you why it is not correct, because I don't want to lead evidence. It suffices to say, DF Wendell Trust, Swissboro, you can't rely on it unless you said, I draw your attention to this annexure, EC12, and for the I pleaded for the following propositions, which was not done in the body of the affidavit in relation to that. Other than that, Justice Zondi, Justices, and members of the court, those are my submissions on behalf of the Commission in this Malapane matter, and unless you have any questions, I am done.
Justice Shaw, any question?
None, thank you.
Justice Adams?
Nothing from my side. Thank you, Justice Zondi.
Professor Ntlama Makanya?
Nothing as well, Judge. Thank you.
Just Professor Puku?
Nothing from my side, Justice Zondi.
Thank you. This question is directed at you, Mr. Tsele and Mr. De Beer. You remember Mr. Bishop promised to send an affidavit
Yes.
to condone the late filing of the answering affidavit. He said it must have been, the attorney was busy preparing it and he must have sent it to him. He's going to check his phone. What's happening?
Judge Zondi, I don't have instruction, but I can
I think
speak to
that-
Mr. Kanyane quickly just to confirm what the position is.
Justice Zondi, maybe I can help. I think the affidavit is ready. It's on its way. It may have been emailed to you, but I've seen it, and you should get it shortly if it hasn't already been emailed.
Okay.
But I've seen the affidavit. It's there.
Okay.
Justice Zondi, maybe on that point, because Dr. Malapane also raises this issue. It's not ideal what has happened, and I have to accept that. And what I mean is, even in our case, I'm conscious of leading evidence, even in our case, my instructions from my attorney, again, was that there was some communication with Ms. Nshapo about the necessity to file a condonation affidavit. As far back as yesterday, it was said, well, in the light of the directions that the matters will be heard anyway, she took the view or was advising us that it was not necessary to burden the court with such an affidavit, specifically for the Dr. Malapane's case. And this ruled the issue of barring. So I accept that perhaps clients sometimes and attorneys err because they communicate with the registrar in good faith, and the registrar gives an indication. Sometimes she'll say directions will come and the directions never come, but that the correct process, of course, is always to err on the side of caution and bring the condonation application. But that is the factual position of what has happened. We accept that the direction, I don't think, subsequently came. But we, with respect, submit that it would not be helpful to the commission, because this is not typical.
Yeah, man, it's political.
Yeah, it's not typical litigation for the court to say, for the applicant to say, gotcha, you filed late, and therefore ipso facto the court shouldn't entertain your affidavit. We are trying to be helpful to the court. The court wants the answers. I apologize that these condonation affidavits haven't been filed in the manner in which they should have, and that seems to have been the errors of the good faith communications with the registrar, who is also no doubt very busy, and we're not shifting any blame. And sometimes a statement is made that a direction will come or will be forthcoming, or it's not necessary to further burden the court, and that's all done in good faith. But the affidavit to which Mr. Bishop alluded to will be the court will be finished with that affidavit. In fact, and an affidavit with respect in relation to this matter. And if Dr. Malapane wants to say something in answer to that affidavit, well and good. We won't reply because the facts are what they are, and it will be very short and explain to the court what I've just said. But those are my submissions, Justices, and
Thank you. Mr. Chabalala, it's your time now to reply. Any reply? Mr. Chabalala?
Thank you, Honourable Justice.
Yes.
I want to indicate to the respondent's representative that we have got a case. It's a fact that the fact that we were given the letter dated the 4th of February made us believe on that date that we are registered with effect from that day. The only surprise is that why were we not informed? And we believe such omission on the part of the respondent has been a flaw. That's the reason why we came to the Honourable Court. And immediately when they says we were not registered, it is not true, Honourable Commissioner, because we were even linked immediately after having been given that letter. We were even linked and we also submitted. We were uploading We uploaded people until 14,000. And those ones, if they can check in their system, they will find, because our main aim was to contend the forthcoming election. We uploaded people in their portal until 14,000 in order to contest nationally. And we were still going to upload until 2 or 3, until 3 or 400,000, because we've got members in all provinces. But the problem is their system has been so slow, and that system only allow one person to punch. It could not allow another person in Limpopo. We talked to Sister Akani of the respondents on several occasions. Why this system only allow one person? And we were told, no, that's how it is. You Chabalala, appointed the deputy president to be the person uploading. So he's the only one who can upload. So that one, Honorable Justice, disadvantage us, and we feel we are disadvantaged by that timetable. That's why we were saying we plead with the Honorable Justice to make sure that we be exonerated from the timetable, or else there must be extension in order to accommodate us to punch the other outstanding 300,000 to 400,000 that are outstanding, because in our office we've got so many people that we're supposed to punch. But due to that problem we experienced on the 8th and also on the 11th, it was impossible for us to punch, and as a result, we could not even effect payment. Just like if you look at the papers, we could not even raise the account. But apparently, if we can be given an opportunity to be registered or...
Yes, Mr. Chabalala. We have lost Mr. Chabalala. Mr. Chabalala. All right, while we are trying to get Mr. Chabalala back online, I think that we can go to Dr. Malapane. Dr. Malapane, yes. Any response, any reply?
Thank you. Yes, I have 3 actually. One is on the IT issue, the other is on the queue, and then the final one is on the issue of the notice to bar. The respondent is actually trying to mislead this court in terms of saying, I said I've registered on the 6th on the system, yet I say I do not have IT skills. I have mentioned in my affidavit, in my filing affidavit, that it was up until I went to the IEC office in Centurion physically, because from the beginning of the year, I've been visiting the website of the respondent, trying to understand how to get the process done. There is nowhere where I saw that I need to acquire the OPA before I can be able to do all these other processes, which I was not even aware of. I went there because of the frustration was now mounting, because I had hoped that maybe the system is developing or something, but when the 6th came, I went physically there. The officials at the IEC are the ones who assisted me to get the registration, to get the OPA registration. And then they keep on saying from my registration up until the first candidate, up until I loaded the first supporter, and then the others. But they have a printout of an IT report that they are exposed to, which clearly outlines to them that after I've registered, obviously we need to account that from the office I needed to come back to our own office. Then I needed to brief people who are supposed to assist me with this. So they will realize that on their own report on the 7th, we tried to triple the effort. It was 3 of us trying to load the signatures on the system. We even worked throughout the night of the 7th up until the early hours of the 8th, practically for the entire day from 6 o'clock on the 7th up until 6 o'clock the following day. We did not sleep. We were continually loading these signatures. So he should not put it as if I am misleading the court to say I don't have IT systems yet, I'm capable to do this and that. It is the information that I got after I went to their office physically in Centurion. There is an office here in Malapane, there's an office in Pretoria, but we are not allowed to go there to assist us with these national elections. We only have to go to Centurion. We went there because we wanted to get this whole process done. Now, on the second one, I have illustrated using different institutions versus their clients. We are clients to the IEC. However they profile us, in terms of preparing to otherwise, we remain clients. And then in this country, there's a principle of Batupil. I have said, when we have begun a process, we are queued in the system. So it is a queue. Whether that queue is physical or that queue is electronic, is immaterial. The fact is we are a queue. And clearly that is where our civilization is moving, that things are going electronically, whether we like it or not. So definitions, automatic physical definitions will assume also on the electronic side. Now, the question is, if I had taken our lists, all our lists, put them in boxes, and then went to Centurion on the 8th, and when 5 o'clock hits and I'm inside their office with their officials assisting me, were they going to say I am barred from the system, or were they still going to continue assisting me after 7? If he's arguing the issue of queue on the electronic system versus it being physical, because of it's clear that from all their presentations, even if I was there, they were still going to say now the time is cut and then I need to leave. You see, if the commission was fair in wishing to assist us clearly with this brand new system, with this very limited time, they should have said we give them our lists, we give them our boxes, our lists, and then they manually enter these signatures, because it takes at least 30 seconds or more to enter one signature. Now imagine entering 3,000 signatures only to get 927 valid. So they relegated that responsibility to us to do it upon us, even though they know that they did not afford us sufficient training. And today they say possibly there's suspicion that we have proper IT skills, which is not true. And then Honourable Justice, I would like to bring, on the issue of the notice, I would like to bring the attention of the court to paragraph 351 and 352 of my heads, under my heads of argument, to say, I am going to quote these ones, to say this notice is of this very same honor, is of this very honourable court, and it's evident that this court has it within their authority to uphold the seriousness of its own directives by barring those who do not recognize them. Directives of the court are not just a mere standard operating procedure to be gone through. Rather, they are serious rules of engagement in the court process, and neglecting them has to bear consequences. Otherwise, our courts are just reduced to mere social pubs. Now, the respondent is trying to downplay the seriousness of the directives of the court. Now, what happens? Every ruling that the court makes becomes a precedence. So a directive of a court has to be complied by. Otherwise, it will just be of the same standard as a social post. We cannot have a situation like that. The respondent is demonstrating its inability to recognize the directives of the court for what it is, and they're busy blaming the registrar of the court for that. These are uniform rules. They are uniform rules that are there. And then I believe that the respondent has to be familiar with the processes of the court, seeing that they are themselves an authority in the election environment. I thank you, Honourable Justice.
Thank you, Dr. Malapane. Justice Strong, any question?
Thank you. I've got no questions.
Justice Adams?
No questions, Justice Only. Thank you.
Professor Makanya?
And no question as well, Judge. Thank you.
Professor Poko?
No questions from my side. Thank you, Judge.
Thank you. Mr. Chabalala. Mr. Chabalala, are still there? We lost him. Okay, thank you very much, ladies and gentlemen. Thanks very much for your presentation. The judgment will be reserved. You'll hear from the registrar as to when the order will be handed down. Obviously, because of the time constraint, we'll have to give the order without reasons, and the reason will follow upon request. Yeah, but thank you very much. And it's late now. It's 6:05. We've been patient enough to assist this court to dispose of these matters. Thank you very much. You are excused.
As the court pleases, Justice Andy.
Thank you.
Thank you, Honourable Justice.
Yes, thank you. Ms. Tapo, just make sure that everybody leave the platform, and then it's going to be us and the